Sababu hiyo tunajua ni kwa nini. Kama kungekuwa na malalamishi ambaye ni ya ukweli, tungeanza na grassroots. Hawa maagent wake na wa UDA waseme kulikuwa na chinda. Lakini for now, hii kitu hakuna agent yoyote ambaye ametoka pande ya Azimio amesema ile form 34B ilikuwa na 34A ilikuwa na makosa. Ile ingine tunatarajia ni kusema ile wakati tulikuwa nafuatilia hii proceedings za koti, tuliona hakuna challenges zilikuwa kwa form 34B, na hiyo ndilikuwa imetoka kwa machinani, na kama hiyo ilipelekwa huko na hakuna mtu amechallenge hadi hizo hesabu zilikuwa mbaya, tunaona ni kweli hii ushindi ilikuwa ule alikuwa ameshida ni William Ruto. Na tugeuliza mtu ya Azimio ambaye ni anaitwa baba na wale watu wanamsupport akubali tu matokeo, kwa maana Kenya haitaendelea namna hiyo. Na kama mtu atarudisha petition next time, nigeuliza majudges waweke jukumu. Kama wewe unataka uchaguzi urudiwe, ujue where you cater for any expenses, kama ni kuprint hizo ballot papers so that we don't repeat the same thing. Kwa maana hii kitu inaonekana ni kama mchezo. Mtu anaambiwa deposit just $1 million, hiyo anaweza pata. Lakini ukiambiwa usimamie uchaguzi about 40 billion shillings, utachidwa, sasa utapeleka hiyo malalamishi.
Na asante sana. Wacha Runu nikaweza kuungana na mkazi mwingine kutoka eneo hili.
Jina langu ni wakili Gashero Wafande. Nimetoka sehemu hii kubwa ya Nyeri. Na maoni yangu ni kwamba siku ya leo ni siku kubwa sana katika jamhuri yetu ya Kenya. Na tunajua koti kubwa liko na jukumu kubwa sana siku ya leo ya kufanya uamuzi. Lakini hapa sisi tunagojea uamuzi, inaweza enda pande yote. Koti ikiamua petition haina maana, ni kumaanisha ya kwamba ushindi wa William Ruto utakuwa wa haki, na yeye atakuwa tayari kuapishwa baada ya siku 7 kutoka siku ya leo. Lakini kikiumana, kwa sababu sisi hatujui sana uamuzi wa koti ni gani, ni kusema ya kwamba uchaguzi inaweza fanywa kwa siku zingine 60 days. Lakini obikumbwa, tumeona venye Kenya tumehangaika, watu wengi wanangojea hii maneno ya uchaguzi iishe, watu warudi kazini, na ile kitu iko watu, sisi tunasema waeke amani katika sehemu yote ya jamhuri yetu ya Kenya. Kama hii petition itatupiliwa bari, tulisikia William Ruto akisema ya kwamba yeye vyovyote vile hii uamuzi utaenda, yeye atakubali. Lakini saidile ingine, wao walisema tu wataweka amani, hawakusema ya kwamba abide na ile decision ya court. Kwa hivyo tunaomba ya kwamba ile uamuzi court itafanya kwa dakika chache siku jazo, watu waheshimu hiyo uamuzi. Lakini kwa nje tunaweza ongea juu ya hiyo uamuzi kwa njia yote ile.
Naam, Nuru na Nick, ningependa kuungana na mzee mmoja kutoka kwa chama cha Gikuyu. Hebu tueleze maoni yako ni yapi kuhusiana na swala hili la maamuzi ya mahakama ya upeo?
Asante sana. Jina langu ni Michael Mugo, Joroga wa Mugo. Mimi ndio naibu mkuu wa kiama ambayo ni chama ya Wagikuyu. Ya kwanza ni kusema kwamba tulifurahia vile wananchi wa Kenya walipojitokeza kwa njia ya amani na wakawa na utulifu, na baada ya uchaguzi hawakuregarega hapo nje ya vituo, kumaanisha tuko na imani na mpangilio wa uchaguzi. Kwa wazee walikuwa na msimamo, na huo msimamo ugali huko, na ni kumaanisha sisi kama jamii ya Wakikuyu na Mount Kenya huwa tunaishi pahali pengi nchini Kenya, na kwa hivyo tunakaa na jamii tofauti, na tunaomba sisi wote tushikilie amani na tukubali matokeo ya uchaguzi vile koti ya upeo itakapoamua siku ya leo. Wakiamua kwamba tutarudi kwa uchaguzi, turudi kwa njia ya utulivu. Wakiamua hatutarudi, tukubaliane na matokeo yaliyotokea, tuunge mkono Rais mteule Ruto na Deputy President Rigathi, tufanye kazi. Kuna wakati Mwai Kibaki alisema, msiogope maneno ya uchaguzi. Uchaguzi ni miaka 5. Na kwa hivyo tusione kama kuna shida itakuwa kwa sababu ya miaka 5. Tuwe na utulivu, tufanye kazi kwa pamoja jamii zote za Kenya, na tuwe kwamba ile ambayo tumeamini hakuna makosa yoyote yalifanya. Kama ulipigia UDA, kama ulipigia Azimio, hakuna makosa na hakuna mtu ako na apology. Kila mtu alifanya kulingana na haki aliyopewa na katiba. Tuliona kitu moja. Majaji waliuliza swali, kama commission ilifanya kazi kwa umoja. Tungependa hata commission ifanye kazi kwa umoja, majaji wafanye kwa umoja, na iwe funzo kwa board zingine zote katika Kenya na commission zingine. Wakipewa kazi, hakuna chairman wa kiimla, wote wanafanya kazi kwa umoja, kwamba hata kama ni board ya shule na board zozote. Kwa hivyo ndio tukifanya, wakati unafanya kazi, umepewa kazi na raia, unafanya ukifikiria wale raia, lakini sio matumaini yako wewe mwenyewe. Kwa hivyo tunaomba koti ya upeo itoe maamuzi ambayo yataleta amani, maamuzi ambayo yataweka Kenya pamoja, maamuzi ambayo kesho ingine tukifanya uchaguzi sisi wote tutakubali imani na tutakuwa na imani na utaratibu wa uchaguzi. Asante sana wazee wote wa Kikuyu na Mount Kenya, tukae kwa amani na jamii zetu zote tukae kwa amani.
Naam, ningependa kuzungumza na mkazi mwingine wa mwisho kutoka eneo hili. Hebu tueleze maoni yako ni yapi kuhusu uamuzi huu wa mahakama ya upeo?
Maoni yangu.
Jina lako tafadhali?
Jina langu naitwa Home Mulage. Mkaji wa hii kituo ya Lolengo Gatito. Sasa mimi ni mmoja ule aliamka asubuhi sana saa 10. Nikaenda kwa kituo ya kupigia kula. Nilikuwa one of agent. Kwa hivyo nilikaa hapa kutoka hiyo masaa yote mpaka saa 6 ya usiku. Na hakuna kile kitu tuliona, hakuna kitu kulikuwa na mbaya kwa uchaguzi. Na hakuna wizi ilikuwa inaendelea huko. Kila kitu tulikuwa tuna sign mzuri na tukaona kula watu walikuwa wanajitokeza kwa uzuri, kukuwa na kwa huko na furugu kwa kituo. Kwa hivyo hiyo election tulifanya fair and fair game. Kwa hivyo ningetaka mimi kwangu mtu anaitwa Wajiko, kwa sababu alifanya kazi yake, apatio light yake ile alifanya. Kwa hivyo mahakama iangalia hapo sana, kwa sababu sasa ikionekana mtu akinyimwa light yake inakuwa baya. Kwa hivyo mimi nataka muamuzi wa koti iendelee mzuri, hakuna favor, hakuna nini. Kwa hivyo iendelee mzuri, na vile koti itasema si tutaamua, tutakubali matokeo yote ya koti vile itasema tunaamua, na tuna maneno mengine. Nasema majaji waendelee kufanya kazi yao mzuri vile inaonekana.
Naam, asante sana. Tutaweza kuzungumza na mama mmoja kutoka eneo hili la Mathira. Hebu tueleze maoni yako ni yapi?
Mimi tunaangalia huko kwa everybody wa Kenya tunajaa sana. Tunataka tusaidiwa everybody. Tuna skill uga unajuu makuta Ruto ashukuru hiyo madaraka ya Kenya. Wakati wa shule tuna skill, wakati tuna.
Naam, asante sana mtazamaji, na nitaendelea kukita kambi hapa nikiwa na mpiga picha wangu ambaye ni Charles Mureithi, ili tukaweza kueleza mengi zaidi na maoni pia ya wakazi, ambapo mahakama ya upeo ukifanya uamuzi huo. Ni hayo tu kwa sasa. Kwako Nick na Nuru.
Asante sana Margaret Kimathi kutoka kaunti ya Nyeri. Bila shaka matarajio mengi, naona uko na askari nyuma yako. Itakuwa vizuri sana kupata simu zao baada ya mahakama ya upeo kutoa uamuzi wake hapo baadaye, Margaret Kimathi. Lakini ndani ya studio mtazamaji tunaye Khalid Hussein ambaye ni mkurugenzi mkuu wa Haki Afrika, na vile vile amekuwa mwangalizi katika uchaguzi wa mwaka 2022 na vile vile uchaguzi ambao ulifanyika ugavana katika kaunti ya Mombasa, na Ishmael Nyeribo ambaye ni wakili. Hapa tunazungumzia kuhusiana na uamuzi huu, matarajio ya Kenya kuhusiana na uamuzi wenyewe.
Naam. Nikirejea kwa Khalid, labda tukiangazia tu swala ambalo ulikuwa ukizungumzia awali, hasa mambo ambayo yamefanywa mwaka huu au katika uchaguzi huu, ambao labda iwapo tutarejelea uchaguzi itakuwa ni tofauti kivipi? Tukiangazia hasa swala la maajenti, nimeona ni swala ambalo limejitokeza sana hasa katika kesi hiyo. Labda kuna kitu tofauti ambacho kunaweza fanywa kuhusiana na maajenti, kwa sababu wanasema labda kuna wale ambao walikuwa wanafika na sio maajenti katika uchaguzi.
Na useni kabla ulijibu, pengine pia kuna swala hili la IEBC. Iwapo mahakama pengine yaamua kwamba turudi debeni, tuna ile tume ya IEBC ambayo Azimio wa Kenya wamekuwa wakiteta kuihusu, itakuwa namna gani?
Naam, labda kwanza nikimjibu Nuru, sisi tulikuwa kule nyanjani na kila observer ambao sisi ni waangalizi wa kura tulikuwa na baji zetu ambazo zilikuwa na jina, zilikuwa na picha. So ingekuwa ni vigumu kwa mfano mimi kufika mahali kusema nataka kuingia na labda sina baji. Lakini jambo ambalo lilitushangaza ni kwamba wale maajenti wa vyama kadi zao hazikuwa na jina wala hazikuwa na picha. Nyingi ilikuwa ni kadi tu imeandikwa election observer. Sasa tulikuwa na wasiwasi kwa sababu mtu yoyote yule anaweza kupewa ile kadi akavaa shingoni akasema anataka kuingia. Ndio pale nikasema ikiwa tutarudia uchaguzi, hatujui maana tunangoja uamuzi, basi lazima IBC waweze kujipanga. Waambie hawa maajenti kama tulivyoambiwa sisi, tutume stakabadhi zetu kila kitu miezi 3 kabla ya kura, ili tuweze kupangiwa, tuoneshwe kila kitu vile inafaa kufanya. Kwa hivyo ni muhimu nafikiri kwa maajenti, kwa sababu unaona kule Bomas wakati rabsha zilipotokea ilikuwa ni kila mtu ameingia pale, hujui nani ni nani na ni vipi. Kwa hivyo ni muhimu IBC waweze kujipanga na mapema. Vile vile tunaona pia jambo jingine ambalo lazima lifuatiliwe ni usalama. Nafikiri security kwa wakati huu uliopita waliweza kujizatiti. Hata sisi tuko na awards tutatoa kwa wale ambao wamefanya kazi nzuri kuleta amani na kuhakikisha kwamba hali imekuwa shwari. Na usalama ukiwa utakuweko, basi tutahakikisha kwamba uchaguzi utakuwa wa huru na utakuwa uchaguzi wa haki.
Naam. Na pengine ningependa nichokoze kidogo, maana nadhani kwamba muda unawadia kidogo, wakati wote sasa majaji watakuwa naingia ili kutoa uamuzi huu. Lakini nichokoze tu kidogo na niulize Ishmael, unahisi pengine mahakama hii ikishikilia uchaguzi wa William Ruto ama ikiidhinisha uchaguzi wake, tuna upande mmoja tuna Raila Odinga ambaye amekuwa kwenye siasa kwa muda mrefu sana, na upande mwingine tunaye Rais Huru Kenyatta ambaye ndiye rais kufikia sasa. Pengine unahisi namna gani hawa, na kidogo singependa kutumia jina la familia, lakini tumie hawa vigogo wa siasa, unahisi pengine hatima yao kisiasa itakuwa namna gani? Itakuwa ndio kwenye kaburi la sahau?
Ni kujibu direct, hiyo itakuwa sawa sana. Unajua watu walisema 2017 Raila amekwisha. Na alijitokeza akakuwa amekuwa kwa uongozi nyanja ya uongozi quote and quote miaka 5 yote. Na ukisema Uhuru Kenyatta, ujue ya kwamba watu wengine wanafikiri ya kwamba Uhuru Raila akishindwa atazama, sijui atapotea. Ukumbuke ya kwamba mzee Jomo Kenyatta alikuwa president paka 1978. Since 1978 first family imekuwa tu, lakini wamekuja kukuwa president 2013. So Gideon Moi, Kalonzo Musyoka, Uhuru Kenyatta, Raila Odinga hawaendi mahali ndugu yangu. Watabaki hapa na tutangoja miaka 5 ambaye ni fupi sana. Misingi itageuka kwa namna ingine na utaona tumefanya uchaguzi mwingine. Kwa hivyo nataka kuhakikishia wale supporters wa Raila Odinga, supporters wa Uhuru Kenyatta, hakuna haja ya kujikasirikia sana ama kuona tu umepoteza. Siasa iko namna hii. Hakuna kitu, na kuhakikishia hapa kwa runinga ya taifa, hakuna kitu itafanywa kwa Gideon Moi, hakuna kitu itafanywa kwa Uhuru Kenyatta. Hawa watu wako imara na watamaliza hii miaka 5. Mimi na wewe ambaye ndio quote and quote tunaitwa hustler, ndio tuko na shida tu. Sisi wenyewe ndio shida. Hawa watu watakula sawa, Kalonzo Musyoka atatembea, unaona Raila Odinga atakuwa sawa sawa na Uhuru atakuwa sawa sawa.
Ishmael, wakili, kama tunavyoona kwenye runinga kwa mtazamaji, ni kwamba hiyo ni feri pale katika kivuko cha Mombasa, na kama unavyoona kati ya yale magari ni baadhi ya magari mengi tu pale nyuma ya polisi, malori na magari mengine ya polisi. Ni ishara kwamba ni maafisa wa usalama, hasa kitengo cha GSU. Fanya fujo uone, wanaingia mjini Mombasa pale. Wanatoka upande ule mwingine, nadhani kwamba ni upande kunaitwaje kule, Likoni. Wanaingia upande wa Mombasa. Sasa mainland bila shaka kuangazia swala hili la usalama, wanataka uamuzi kutolewa. Kama unazoa fujo
unajua tuseme hivi, unaona sasa askari wanajipanga. Pale mahakamani kulitokelezea jambo eti National Security Council eti imeenda kufanya tafaruku fulani pale Bomas. Lakini angalia sasa, hawa ni maaskari. Kwa nini wamekuja kuchunga wananchi wa Mombasa na pia hapa Nairobi pia wamejiweka barabarani. So unaweza sema hapana, wanajua wamejua vile matokeo itakuwa. Kuna mahali saa zingine si mzuri kwanza kuingisha kwa siasa vyombo vya usalama. Hawa ni haki yao na wanafanya kazi. Kama polisi akiitwa kwa nyumba yangu eti kwa sababu kuna jambo fulani, hajakuja kwa ubaya ule mwingine, amekuja kwa sababu ni lazima usalama uidhinishwe.
Kweli. Nilikuwa najaribu kuangalia ni upande wa ferry ama ni upande wa island, lakini ni kweli kwamba wale sani askari wamevuka kutoka upande wa Likoni.
Kidogo kwanza Hussein.
Hussein, asante sana. Kidogo shikilia tu hapo, manake mtazamaji, tayari majaji wameingia mahakamani sasa. Tutakupeleka kule moja kwa moja.
Good afternoon and welcome to the Supreme Court of Kenya for the delivery of judgment in presidential election petition number E005 of 2022 as consolidated with E001, E002, E003, E004, E007 and E008 of 2022, Raila Odinga and 6 others versus William Ruto and 13 others. The Honorable Chief Justice and the President of the Supreme Court is presiding.
Thank you. Very good afternoon, ladies and gentlemen. Yes, this is the judgment of the court, which is delivered pursuant to Rule 23(1) of the Supreme Court Presidential Election Petition Rules 2017 in the presidential election held on the 9th August 2022. This is an abridged version of the judgment. The full judgment will be delivered after 21 days. Kenya is a sovereign multi-party democratic state whose foundations are firmly spelled in the Constitution. The Kenyan people's quest for electoral reforms since independence is well documented. That notwithstanding, and even without going back to the pre-1992 era, every cycle of elections has been highly contested, with the exception of 2002. This speaks to a background of distrust of the administration of our electoral process. Informed by this setting, Kenyans made a decision to vest the Supreme Court with the jurisdiction to determine questions regarding the validity of a presidential election under Article 140 of the Constitution. The reactions following the declaration of results of the presidential election of 9th August 2022 shows that the Independent Electoral and Boundaries Commission, IEBC, has not yet garnered universal public confidence and trust in the internal management of the Commission and elections. On the 15th August 2022, 6 days after the general elections were held, Mr. Wafula Chebukati, the chairperson of IEBC, announced the following results. Raila Odinga, 6.942,930 votes, representing 48.85%. William Ruto, 7.176,141 votes, representing 50.49%. David Wahiga, 31,987, representing 0.23%. George Wajakoya, 61,969, representing 0.44%. Based on the aforesaid results, the chairperson of IEBC declared William Samoei Ruto the first respondent, the presidential candidate for the United Democratic Alliance Party, as the president-elect. This declaration has precipitated a total of 9 presidential petitions that are filed before us, to wit, number 1, presidential election number 001 of 2022, John Njoroge Kamau versus Wafula Chebukati and 3 others, and Raila Odinga and 7 others named as interested parties. The second petition is presidential election number 002 of 2022, Youth Advocacy Africa and another versus IEBC and 12 others. Third petition, presidential election petition number 003 of 2022, Kerif Khalifa and 3 others versus IEBC and 3 others. Fourth petition, presidential election petition number 4 of 2022, David Kariuki Ngari versus IEBC and 9 others. 5, presidential election petition number 5 of 2022, Raila Odinga and another versus IEBC. 6, presidential election petition number 6 of 2022 by Moses Kuria and others versus Honorable Raila Odinga and 4 others named as interested parties. Number 7, presidential election number 007 of 2022, Okia Omtata Okoiti and others versus IEBC and others. Number 8, petition number 008 of 2022, Julia Nyoka Bichege and others versus IEBC and 3 others. And the last one, but not least, petition number 009 of 2022, Ruben Kigame Richete versus IEBC and others. In addition to these petitions, we received a total of 24 interlocutory applications and 1 preliminary objection, which were filed in this court. 2 of the presidential election petitions were struck out. That is petition number 006 and 009 of 2022 for failure to meet the constitutional threshold as set out under Article 140 of the Constitution. On 29th August 2022, this court also admitted 3 amici curiae briefs by the Law Society of Kenya, the Kenya section of International Commission of Jurists, and John Warubengo and 2 others. Upon perusing and considering the issues raised in the remaining presidential election petition numbers 001, 002, 003, 004, 005, 007, and 8, the responses and the submissions filed thereto, this court found that all the 7 petitions substantially raised similar issues and sought similar reliefs. Consequently, on 30th August 2022, this court ordered that the 7 petitions be consolidated and designated presidential election petition number 005 of 2022 as the read file. From the consolidated petition, the responses filed and submissions filed by all the parties, the court crystallized MBIS application and the 2 MBIS users with the same logging identification, risking unauthorized system users, possible interference, change of particulars on the activation of voters in the system, IEBC's failure to set up access, decertification, and user activity review process. And IEBC was also arranged to have failed to respond to requests by auditors for crucial information. On the integrity of the technology deployed, it was the case for the seventh petitioner that in order to comply with Article 86 of the Constitution and Section 44 of the Elections Act, the technology deployed must be simple, accurate, verifiable, secure, accountable, and transparent. On the simplicity of technology, the seventh petitioner contends that the KIMS kit failed the tests as they were not easily usable by ordinary citizens without expert knowledge. They further assert that IEBC was expected to procure and put in place a technology necessary for the conduct of the general election at least 120 days before the election and ensure consultation with the relevant agencies, institutions, and stakeholders. Furthermore, the petitioners arranged that IEBC violated its constitutional duty by delegating the design, implementation, and conduct of the KIMS components of the election to a foreign company, Smartmatic International Holdings, BV. As a result, IEBC staff and the public did not have full comprehension of the KIMS components. They conclude, therefore, that IEBC abdicated and surrendered its role to conduct elections to Smartmatic, and that IEBC vigorously fought any attempt to subject Smartmatic's activities to accountability and transparency, including the safeguards required by Regulations 61, 69, and 75 of the Elections General Regulations 2012. In response, IEBC has submitted that the electoral system met the constitutional threshold, that all the necessary information was accessed only by the authorized persons. The information was accurate, complete, and protected from malicious modification, either by authorized or unauthorized persons. IEBC maintained an audit trail on activities related to information, and that the information was available and could be authenticated through the use of various security features. In further response, IEBC contended that they engaged KPMG on 7th April 2022 to conduct an audit of the register of voters, which was submitted on 18th June 2022. In addition, it issued a briefing on the report on 20th June 2022, summarizing the thematic areas therein and disclosing its findings as well as actions taken to remedy the issues identified. It also conducted its annual audit in compliance with Regulations 11 and 12 of the Election Technology Regulations 2017 and a certification of compliance issued to it on 3rd August 2022. IEBC relied on sworn affidavits by Michael Ouma, Moses Sunkuli, and Majan Hussein Majan on 26th August 2022, which were to the effect that it published the interim report by KPMG on 8th June 2022 and embarked on remedial measures aimed at effecting the recommendations ahead of publication of the final report. It was ascertained that it could not publish the full final audit report, as doing so would compromise the integrity and security of the electoral technology system, considering the provisions of the Data Protection Act, which imposes a duty to protect the data of Kenyan voters. On the other hand, the first and second respondents urged that even if there was failure of technology, it did not vitiate the result of the presidential election. Upon considering all the printing submissions and the ICT scrutiny and inspection tallying and recount report, which fully examined the IEBC's result transmission system, RTS, we are not persuaded by the allegation that the technology deployed by IEBC failed the standard of Article 86A of the Constitution on integrity, verifiability, security, and transparency for the following reasons. 1, whereas it is true that the KIMS kit failed in 235 polling stations, 86,889 voters were granted the right to vote manually, and the requisite forms 32A were duly filed. This happened successfully in Kibwezi West constituency and parts of Kakamega County. 2, while the audit report was released to the public 7 days before the 9th August election, the register of voters was used at the election without any apparent anomalies. 3, Smartmatic was procured to provide the necessary technological infrastructure, as IEBC did not have the capacity to do so. No credible evidence meeting the requisite standard of proof of access to the system by unauthorized persons was adduced by the petitioners. The scrutiny report prepared by the registrar of this court did not reveal any security breaches of the IEBC's RTS. IEBC successfully deployed a biometric voter register system which captures unique features of a voter's facial image, fingerprints, and civil data to register and update voter details across the country and also in the diaspora. The BVR captures a voter's facial image, fingerprints, and civil data, which features are unique to each of the voter. In compliance with Section 6A of the Elections Act 2011, IEBC opened the register of voters for verification of biometric data by members of the public for a period of 30 days. Thereafter, the register was revised to address issues arising from the verification exercise. KPMG then audited the register, and we are satisfied that the inconsistencies and inaccuracies identified during the audit were somewhat successfully addressed. The second issue was whether there was interference with the uploading and transmission of Forms 34A from the polling station to the IEBC public portal. The first petitioner arranged staging that a person who had access to the RTS intercepted, detained, or stored Forms 34A temporarily to convert or manipulate it before uploading it on IEBC's public portal. It is arranged also on 11th August 2022, IEBC dumped over 11,000 Forms 34A on the public portal between 11 to 11:09 hours. To rebut this allegation, IEBC and its chairperson, in their response dated 26 August 2022, denied staging and unauthorized intrusion of the RTS. In that regard, they urge that every image of Form 34A was uploaded immediately after the transmittal of results. The form was received as evidence by the timestamp. Similarly, the first respondent denied these allegations. Our finding: 1, no credible evidence was presented to prove that anyone accessed the RTS to intercept, detain, or store Forms 34A temporarily before they were uploaded to the public portal. The allegation that 11,000 Forms 34A were affected by staging was similarly not proved. 2, the allegation that IEBC, its officials and strangers used a tool to tamper with the Forms 34A before converting them to the portable document format, that is PDF, that eventually appeared on the public portal, was sufficiently explained when IEBC demonstrated how KIMS captured and transmitted the image of Form 34A. Accordingly, we dismiss that allegation. 3, during the ICT scrutiny, it turned out that the transmission logs produced in the affidavit of Justice Nyangaya were of no probative value. The registrar's report shows that the original Forms 34A from the contestant polling stations, which were allegedly intercepted, were exactly the same as those on the public portal, and the certified copies that were presented to this court pursuant to the provisions of Section 12 of this reporting, from verification to transmission of results. Seen in the middle server, configured to the IEBC's VPN network, and no evidence was produced to show that the chairperson of IEBC and staff were part of the arranged conspiracy to stage the transmission process. 9, whether there was a difference between Forms 34A uploaded on the IEBC public portal and the Forms 34A received at the National Tallying Center, and Forms 34A issued to the agents at the polling stations. On this issue, the first petitioner's case was that there was deliberate manipulation and tampering with Forms 34A, as demonstrated in the affidavits, to the effect that votes were being deducted from the first petitioner and being added to the first respondent. To support this petition, evidence was contained in the affidavits of Honorable Martha Karua, sworn on 21st August 2022, Celestine Anyango Opio, Arnold Ochieng Oginga, and John Mark Githongo, which was sworn also on 21st August 2022, and a further affidavit sworn on 28th August 2022. Dr. Nyangasi also swore an affidavit on 21st August 2022, and so was Martin Papa, to support that allegation of handing and subtraction of votes. On the other hand, IEBC and its chairperson urged that all Forms 34A transmitted to IEBC portal were not interfered with or manipulated. Further, that the Forms 34A signed at the polling station and issued to the agents were identical to the Forms 34A uploaded on the public portal, and delivered to the National Tallying Center at the Bomas. It was contended that in any event, IEBC used the original physical forms 34A to tally, verify, and declare the presidential election results. This court ordered scrutiny of the forms from the 41 polling stations outlined in the affidavit of Celestine Opio to ascertain the allegation of interference. And this is our finding. 1, there were no significant differences captured between the forms 34A uploaded on the public portal and the physical forms 34A delivered to Bomas that would have affected the overall outcome of the presidential election. B, no credible evidence was presented to support the allegation that forms 34A presented to agents differed from those uploaded to the public portal. The report by the registrar of this court confirmed the authenticity of the original forms in the sampled polling stations. The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information, were not credible, as the registrar's report confirmed that all the forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented swore any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them. Yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it bears repeating that affidavits filed in court must deal only with facts which an deponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code that swearing to falsehoods is a criminal offense, and 2, that it is an offense to present misleading or fabricated evidence in any judicial proceeding. Section 114 of the Penal Code states, and I quote, "Any person who swears falsely or makes a false affirmation or declaration before any person authorized to administer an oath or a declaration upon a matter of public concern, and at such circumstances that the false swearing or declaration, if committed in a judicial proceeding, would have amounted to perjury, is guilty of a misdemeanor." One of the most serious losses an advocate may ever suffer is the loss of trust by judges for a long time. Such conduct amounts to interference with the proper administration of justice. The contents of the affidavit of John Mark Githongo, which may contain forgeries, are also dismissed for not meeting the evidential threshold. Those averments contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove the allegation that Forms 34A were fraudulently altered by a group situated in Karen under the direction of persons named in the affidavit, and video clip attached to it. As a matter of fact, these two affidavits amount to double hearsay and incapable of being proved at each of the rears. We turn to Form 34A for Gacharaigo Primary School, which was sensationally presented by Madam Judy Soweto, advocate, to show that one Jose Kamango accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value. The Kim's kit relating to Songonyo Primary School, which bore the same serial number with another, was admitted by IMBC as an inadvertent manufacturer's error. We are also satisfied that the two kits and other identifying features that were markedly different, including the timestamps and polling code, and therefore nothing turns on this anomaly. Therefore, to the question whether there was a difference between Forms 34A uploaded on the IMBC public portal and those received at the National Tallying Center and those issued to the candidates' agents at the polling station, we have found none. Issue number 4, on whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui, Rural, Kachiriba, Rongai and Pokot South constituencies, and electoral ones in Nyaki West, in North Imenti constituency, and Kwanjenga in Embakasi South constituency, resulted in voter suppression to the detriment of the petitioners, and especially in petition number 5 of 2022. It is common knowledge that IMBC postponed elections for various seats during the general elections of 9th August 2022 due to mix-up of ballot papers in the above-named electoral units. It is the combined case of the first and second petitioners that, in terms of Articles 136, 2A, 177(1), and 181, as read with Article 1 of the Constitution, the chairperson of IMBC had no jurisdiction to postpone elections in those areas. That Section 55B of the Elections Act is inconsistent with the Constitution and therefore void to the extent that it purports to donate to IMBC power to postpone elections in the constituency, county, or ward, contrary to the Constitution, and the postponement undermined the conduct of free, fair, credible elections by depriving the voters an opportunity to vote for all the candidates on the dates stipulated by the Constitution. The petitioners further contend that the postponement of elections and the overall effect of suppressing voter turnout in the electoral units in question, which was prejudicial to him. Both the first and third petitioners also believe that elections were deliberately postponed in Kakamega and Mombasa counties. It was arranged that these areas are considered to be first petitioner strongholds, and as such, the postponement of elections worked to his disadvantage and handed that benefit to the second respondent. These assertions were denied by IMBC and its chairperson. They, however, admitted that they experienced confusion with the printed ballot papers and explained that they only discovered the mix-up on the eve of the election when the ballot papers were being distributed to the polling stations. That as a practice, ballot papers can only be opened on the eve of the election day to avoid any mischief, and that by the time the mix-up was discovered, it was logistically impossible to print and replace the ballot papers in time for the elections. For this claim to succeed, it must be demonstrated first, IEBC and no authority in law to postpone the elections, and secondly, that the postponement was deliberate and calculated to suppress voter turnout so as to affect the result by reducing the petitioners' overall votes. We've looked at the provisions of Section 55B of the Elections Act, which provides for circumstances when elections can be postponed in a particular electoral unit, including in cases of emergency. We are therefore satisfied that on the basis of the foregoing provision, the third respondent and the requisite power to postpone election in the constituencies, counties, and wards in question. Concerning the allegation of voter suppression, we note that voter suppression is generally recognized as a political strategy which takes many forms, but whose practical effect is ultimately to reduce voting by deliberately discouraging or preventing targeted groups of people from exercising their right to vote, and thereby to influence the outcome of an election. It therefore goes against the letter and the spirit of Article 38, which guarantees every citizen the right to make political choices based on universal suffrage. As regards this allegation, it has not been shown that by postponing elections in the named electoral units, IEBC acted in bad faith or was influenced by irrelevant factors and considerations. From the explanation tendered, we are satisfied that the postponement was occasioned by a genuine mistake, which in our view could have been avoided had the members and staff of IEBC been more diligent when they went to inspect the templates in Athens, Greece, where the printing of ballot papers was undertaken. In the absence of any empirical data, we cannot find a basis upon which to conclude, as a matter of fact or evidence, that the postponement affected voter turnout, as a consequence of which the first petitioner alone, as a presidential candidate, suffered disadvantage. At any rate, the nature of the ballot being an individual decision and secret, there may be other factors to which the turnout in the named units can be attributed. From the evidence on record, however, it appears to us that 2022 general election recorded one of the lowest turnouts since the introduction of multi-party political system some 30 years ago. If there was a low voter turnout, it affected all the 6 categories of candidates, and its explanation, in our view, lies elsewhere, but certainly not a calculated suppression. On the other hand, in rebuttal to these claims, IEBC illustrated with examples to our satisfaction that there was no nexus between the postponement of elections and voter turnout in the affected units, far from the fact that this claim was undoubtedly just another red herring. It has nothing to do with the question under review, and accordingly we reject it and hold that there is no proof that the postponement resulted in voter suppression to the detriment of the first petitioner. Whether there were whether there were unexplainable discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 5. The first petitioner was categorical that there was systemic ballot stuffing in certain counties, mainly in the Rift Valley and central parts of Kenya, where, according to him, a total of 33,208 votes were cast for president only, without corresponding votes for the other elective positions. On the part of IEBC and the chairperson, while acknowledging that indeed in some instances there was vote differential between those cast for president and for other positions, but maintained that they were insignificant, and those instances related to votes by prisoners and citizens in the diaspora who only vote for the president but did not take part in other elective positions. The differential also includes rejected ballot papers and stray votes which do not count as valid votes. The well-established principle that the person who asserts a fact must prove it casts the burden upon the first petitioner to demonstrate that there were instances of ballot stuffing of such a magnitude as to justify the nullification of the presidential election. Ballot stuffing, which is an illegal addition of extra ballots, is a type of electoral fraud aimed at swinging the results of an election towards a particular direction. Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then, without more, it must follow that there was fraud. We find that fraud is a serious criminal offense, and it must be proved beyond reasonable doubt under Section 5N of the Election Offences Act. It is indeed an offense for a person to vote more than once in any election. IEBC has provided a plausible explanation for the vote differential, citing categories of voters who only vote for the president, such as prisoners and Kenyans in the diaspora. There were an insignificant number of stray votes whose combined effect cannot justify nullification of the election. Finally, on this point, a general election in Kenya comprises of 6 different separate elections held concurrently on the same day. Such elections are held by secret ballots, and one cannot predetermine the voter turnout or how voters will vote in each election. None of the parties has flagged anything so significant that it would have affected the outcome of the presidential election vis-a-vis the other 5 elections held on the same day. We find, therefore, there were no unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. On issue number 6, whether IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138, 3C, and 138.10 of the Constitution. This issue arises from the printings in all the petitions as consolidated. Based on the said printings, the affidavits sworn in support thereof, and the written and oral submissions by parties, two viewpoints regarding the meaning, scope, and application of Article 138, 3C, and 10 of the Constitution have been advanced. On the one hand, the petitioners submit that pursuant to the foregoing provisions, the role of verifying and tallying of votes as received from polling stations countrywide is vested in the Commission as a corporate entity and not the chairperson of the Commission. It is their argument that the chairperson cannot undertake this task to the exclusion of other commissioners. They submit that the language of Article 138(3)(c) does not envisage a situation where the chairperson can arrogate to himself unfettered authority to verify and tally the results at the National Tallying Center without involving the other commissioners. Such action, they contend, would not only be unconstitutional, but would be sufficient ground without more to nullify an election of a president-elect. In support of their argument, the petitioners cite the Court of Appeal decision in IMBC versus Mainakiai and 5 others as affirmed by this court in the case of Raila 2017. The petitioners further submit that Regulation 87(3) of the Election General Regulations is unconstitutional to the extent that it purports to vest the power of verification and tallying in the chairperson of IMBC. On the other hand, the first, second, and third respondents submit that power to verify, tally, and declare results of a presidential election at the National Tallying Center is the exclusive preserve of the chairperson of IMBC. According to them, there is nothing unconstitutional about Regulation 87(3) of the Elections General Regulations. The said regulation, the respondents submit, makes no mention of commissioners other than the chairperson. At any rate, the respondents argue Article 138(3)(c) of the Constitution does not envisage a situation where it is the commissioners who personally undertake the task of verifying and tallying the results as entered into the thousands of Forms 34A. Such an undertaking would be humanly impossible, they submit. For good measure, the respondents submit that Section 11A of the IMBC Act provides that the chairperson and members of the Commission are responsible for the formulation of policy and strategy of the Commission and oversight. In their view, the Act does not contemplate a situation where commissioners would be directly involved in the verification and tabulation of presidential election results. The task of verification and tallying, as stated by the respondent, is executed by the staff of the Commission under the direction and supervision of the Commission Secretary, who in turn reports to the chairperson. As to whether the chairperson acted unilaterally in verifying and tallying the presidential election results at the National Tallying Center, the petitioners claim that indeed this is what happened. It is the petitioner's case that the chairperson published an illegal Gazette Notice number 4956 of 2022, in which he designated himself as the presidential returning officer, a position unknown in law and the Constitution. Having done so, the petitioners state that the chairperson proceeded to conduct the verification and tallying process to the exclusion of other commissioners, each of whom he had assigned territorial roles and related to the verification and tallying exercise. On his part, the chairperson of IMBC submitted that although he has the exclusive authority to verify and tally the presidential election results as received at the National Tallying Center, He did involve the other commissioners in the exercise before eventually declaring the final results. He submitted that he did this in the spirit of teamwork. The chairperson of IEBC states that indeed the 4 commissioners were involved in the preparation of the 9th August general elections from the time of their swearing into office all the way to the verification and tallying of results at the National Tallying Center until they withdrew from the exercise just when he was set to declare the final result. Having considered all the parties' submissions, we find that pursuant to Article 138(3)(c) of the Constitution, the power to verify and tally presidential election results as received at the National Tallying Center vests not in the chairperson of IEBC, but in the Commission itself. The latter carries out this exercise through its secretariat staff, technical personnel, and any other persons hired for that purpose under the oversight and supervision of the chairperson and the other members of the Commission. In line with this court's decision in Raila Odinga versus another versus IEBC and 2 others, as reported in 2017 Kenya Law Report, popularly known as Raila 2017, and the Court of Appeal decision in IEBC versus Maina Kiai, we also find that the chairperson cannot arrogate to himself the power to verify and tally the results of a presidential election to the exclusion of other members of the Commission. Indeed, Article 138(10) of the Constitution, although the power to declare the result of a presidential election after verification and tallying is vested in the chairperson, he does so only as a delegate of the Commission. Consequently, to the extent that Regulation 87(3) of the Elections General Regulation purports to vest the power of verifying and tallying presidential election results as received at the National Tallying Center solely on the chairperson to the exclusion of other members of the Commission, the same is contrary to and inconsistent with the provisions of the Constitution. That said, we, however, take cognizance of the fact that the 4th, 5th, 6th, and 7th respondents, referred to as the 4 commissioners, actively participated in the verification and tallying exercise from the beginning up to and until just before the declaration of the result by the chairperson. They took turns announcing the results as verified and tallied, and were present and active during the actual verification and tallying at Bomas. An example is when one of them, Justice Nyangaya, stood on the podium to announce to the public results and also announced an adjustment that had been occasioned by errors of tabulation. The events of 15th August 2022, therefore, came as a surprise. As the public waited for the chairperson of IEBC to declare the final result, sporadic violence broke out at Bomas. The violence swiftly was contained by the security forces, but there was unexpected drama as 2 different factions of the Commission began to emerge. Kenyans found themselves watching an appalling split-screen scenario on their television sets. On one part of the screen was the chairperson readying himself to declare the results in accordance with Article 138(10) of the Constitution. On the other part of the screen were the 4 commissioners on the runs of the Serena Hotel, Nairobi, from where they announced that they would not own the results that were soon to be declared by their chairperson. The 4 commissioners informed the public of their rejection of the yet-to-be-announced results, terming them opaque, due to the manner in which the chairperson had been conducting the verification and tallying exercise. In his affidavit dated 25th August 2022, Justice Nyangaya affirmed that the chairperson's actions during the tallying and verification exercise at Bomas made it difficult to ascertain the total number of votes cast and the actual number of votes attained by each candidate, so as to enable him authoritatively state the commission and declared accurate results. All the petitioners have anchored their arguments for the nullification of the 9th August presidential election in Taharia on the walkout from the Bomas by the 4 commissioners. They contend that by rejecting IEBC's results on grounds of opaqueness of the verification and tallying process, they called into question the credibility of the entire election. They further submitted that being in the majority out of the 7-member commission, their view should prevail and the election should be nullified. It is the petitioner's argument, therefore, that a dysfunctional commission cannot deliver a credible election. We note that apart from their 11th hour denunciation of the verification and tallying process and their averments regarding the conduct of the chairperson, the 4 commissioners have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson. Critically, they have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, at the Serena Hotel press briefing, the 4 commissioners acknowledged that thus far the entire election had been managed efficiently and credibly. The chairperson on his part did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy, an institution that obviously needs far-reaching reforms, of which we shall say more in our detailed reasons. But are we to nullify an election on the basis of a last-minute boardroom rapture, the details of which remain scanty and contradictory between the chairperson of the commission and some of its members? In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance, as they made their political choices pursuant to Article 38 of the Constitution? To do this would be tantamount to subjecting the sovereign will of the Kenyan people to the quorum antics of IEBC. This we cannot do. Clearly, the current dysfunctionality at the Commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that notwithstanding the divisions apparent between the chairperson and the 4 commissioners, IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution. Issue number 7, whether the declared President-elect attained 50+1 of all the votes cast in accordance with Article 138 of the Constitution. The first second and third petitioners averred that the first respondent did not garner 50% plus 1 of the total votes cast, and therefore did not meet the threshold provided by Article 138(4)(a) of the Constitution. They anchored their claims on the basis that in order to determine whether a candidate has attained 50% plus 1 of the votes cast, this ought to be calculated based on the total number of votes cast, excluding rejected votes. They argued that 50% of 14,353,165 votes, in their view, were the valid votes cast, which amounted to 7,176,582.77 votes. They therefore contended that by attaining 7.176141 votes, the first respondent did not meet the constitutional threshold to be declared president-elect. Supporting the claim that the first respondent did not meet the 50 plus 1 constitutional threshold was the sixth petitioner. His contention was founded on the backdrop of a press briefing issued by the chairperson of IEBC after the official closure of voting on 9th August 2022. According to the sixth petitioner, the chairperson of IEBC announced that the voter turnout was 65.4% of the total number of registered votes based on the verification of the KIMS kits which were functional during the process of voting. In addition, the sixth petitioner urged that the voter turnout of 65.4% did not include some 238 polling stations where the KIMS kit had malfunctioned, necessitating use of the manual register. It was therefore urged that the minimum number of votes cast could not be less than 14,466,779. Additionally, that this number was bound to increase once the number of votes from the areas that used the manual register were included. The sixth petitioner further claimed that a summation of the minimum number of votes cast and unturned manual votes would represent the actual voter turnout. In challenging the declaration made by the chairperson of IEBC, the sixth petitioner averred that the final tally, published in Form 34C, only accounted for 14,326,641 votes cast, including some 113,614 rejected ballots. The sixth petitioner contended that this tally did not factor in some 140,138 votes cast using the manual register. The sixth petitioner computed this number by subtracting 14,326,641 declared votes cast from 14,466,779 generated by the sixth petitioner as representing 65.4% of the voter turnout. Referring to the tallies in Form 34C, the sixth petitioner summed the number of votes cast for each candidate as follows: Raila Odinga, 6,942,193; William Ruto, 7,176,141; Wahiga Mwaura, 31,987; and George Wajakoya, 61,969, adding to a total of 14,213,027. He then added 138,000 arranged to be unturned votes and this yielded a total of 14,353,165 total valid votes, which the sixth petitioner used to compute the percentages garnered by each candidate as follows. William Ruto, according to him, garnered 49.9%, Raila Odinga 48.3%, Wahiga 0.22%, and Wanjakoya 0.3%. It is on this basis that the sixth petitioner grounded the claim that none of the candidates met the constitutional threshold as set out in Article 138(4)(a). IEBC and its chairperson disputed the sixth petitioner's claim. They submitted that the declaration of results is based on the number of people identified as having voted on the KIMS kit and not the total persons on the voters register as arranged. They contended that the final voter turnout comprising of the voters who were identified through the KIMS kit and those who voted manually was 64.76% and not 65.4% as arranged by the petitioners. They urged that the announcement held by the chairperson of IEBC on 10 August 2022 was immediately clarified during the same press briefing. And evidence of this correction was provided to this court in an affidavit of the first and second respondents in Presidential Election Petition number 7 of 2022. According to IEBC and the chairperson, 14,239,862 voters were identified using the KIMS kit, while 86,889 voters were identified using the printed voter register. Therefore, the total valid votes cast were 14,213,137, while the total number of rejected ballots were 113,614, constituting 14,326,751 total votes cast. They illustrated that the first respondent garnered 7.176,141 votes against 14,213,137 total valid votes cast, yielding a percentage of 50.49 to meet the requisite constitutional threshold for a candidate to be declared president-elect. In the upshot, the percentage attained by each candidate was as follows: Raila Odinga 48.84%, William Ruto 50.48%, Waiga Mwaure 0.22%, and George Wanjakoya 0.43%. IEBC and its chairperson also submitted that the KIMS kits malfunctioned in 235 polling stations, necessitating the use of the printed voter register. In these polling stations, backup KIMS kits were later deployed for purposes of results transmission. The first respondent, in response to the question of 50+1 constitutional threshold, maintained that he attained the threshold under Article 138(4) of the Constitution as elaborated by the IEBC and the chairperson. This court has considered the differing formulas and threshold arguments presented by various parties to this petition. While the first, second, and third petitioners raised pertinent questions connected to this issue, we shall address them together with those of the sixth petitioner, who has addressed and focused on the issue as specifically framed in detail. It must be restated that the case made by the sixth petitioners concerns a data-specific threshold as enunciated under Article 138(4) of the Constitution, that without attainment of which there can be no declaration. This data-specific threshold is what this court declared in John Arun Mwau and 2 others versus IEBC and others. Petitions numbers 2 and 4 of 2017, consolidated, referred to as the ultimate yardstick for determining the winner in a presidential context. In Raila Odinga and 5 others versus IEBC, petition number 5, 3 and 4 of 2013, this court asserted that rejected ballot papers do not constitute a vote cast to be included in calculating the final tally in favor of a presidential candidate. We are not persuaded by amicus curiae's brief, that is Law Society, who attempted to persuade us to consider our position on this finding. We reiterate that rejected votes cannot be taken into account when calculating whether a presidential candidate attained 50% plus 1 of the votes cast in accordance with Article 138(4) of the Constitution. Similarly, in the same Raila 2013 case, the court further laid down the parameters of burden and standard of proof in electoral disputes. More specifically, the burden and standard of proof required in disputes challenging the outcome of a presidential election. And this is what the court said, I quote, in the case of data-specific electoral requirements such as those specified in Article 138(4) of the Constitution, for an outright win in the presidential election, the party bearing the legal burden of proof must discharge it beyond any reasonable doubt. The question that follows was whether the petitioners challenging the attainment of 50% plus 1 constitutional threshold and the computation by the 6th petitioner in general met the standard of proof settled by this court in Raila 2013 case. The premise of the 6th petitioner's percentage computation was a press briefing made by the chairperson of IEBC on 10th August 2022, when the evidential burden shifted to IEBC and its chairperson, as it does in election cases. They produced video evidence correcting the percentage voter turnout to read 64.6 at the time of the briefing. This percentage, however, did not include reports from all the Kim's kits and 86,889 voters who were identified manually using the printed register of voters. In our view, the assertion by the 6th petitioner that the percentage voter turnout was firstly predicated on the uncorrected percentage given by the chairperson of IEBC was negated by evidence adduced to prove the correction. Secondly, the 6th petitioner based his percentage of voter turnout on the total number of registered voters, while the chairperson of IEBC made reference in the press briefing to the number of registered voters who were identified through the Kim's kit progressively. The 6th petitioner also asserted that rounding off of votes cast in a presidential election as a means of assessing the threshold under Article 138(4) of the Constitution kills and bars voters, which is illegal and unconstitutional. We have deliberated on this proposition and found that it is not mathematically sound and that the rounding off done by IEBC and its chairperson was correct. Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution. On the voter turnout, therefore, we find that the formula predicated on the number of voters identified through Kim's kits progressively and used by IEBC and the chairperson to generate a percentage of 64.76% was correct. Having settled the issue of voter turnout, we must ask ourselves whether in the making of the declaration, the chairperson of IEBC applied the formula in Article 138(4) of the Constitution, which is total votes cast less rejected votes divide by 2 must always give 50% plus 1 vote. Given the numbers that were presented to us by IEBC and the chairperson, this will translate to 14,213,137 divided by 2 plus 1, which makes 7.106,569. The question that must inevitably follow is whether this formula, when applied, will confirm that 7,106,569 votes is less than 7.176,141, which represents the number of votes received by the first respondent. We find that it is, as such, on the basis of the foregoing formula and from the numbers provided by IEBC and its chairperson and the declaration by the chairperson of the President-elect on 15th August 2022, it is our finding that the declared President-elect attained 50% plus 1 of all the votes cast in accordance with Article 138(4) of the Constitution. Issue number 8, on whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. Although the petitioners have provided numerous averments pointing to possible irregularities and illegalities marked by failure of technology, arranged voter suppression, printing and utilization of Book 2 of 2, hiyo preparation by the IEBC and its chairperson, commission indiscretions, transposition anomalies, agent absence, and many others, we are of the view that the pointed illegalities and irregularities were not of such magnitude as to affect the final result of the presidential election. We will delve deeper into the details of this issue in our recent judgments. Last issue, what reliefs and orders can the court grant? Under Article 163(3) of the Constitution, it is provided that the Supreme Court will have A, exclusive original jurisdiction to hear and determine disputes relating to the election of the office of the President arising under Article 140. And Article 140 provides, I quote, a person may file a petition in the Supreme Court to challenge the election of the President-elect within 7 days after the date of the declaration of the results of the presidential election. 2, within 14 days after the filing of a petition under Clause 1, the Supreme Court shall hear and determine the petition, and its decision shall be final. If the Supreme Court determines the election of the President-elect to be invalid, a fresh election shall be held within 60 days after the determination. In exercising its jurisdiction pursuant to these provisions, the court sits as an election court with a mandate to determine the validity or otherwise of the election of the President-elect. It is clear to us that the jurisdiction of the court is quite circumscribed in terms of the orders or reliefs it can grant following the hearing and determination of the election petition under Article 140 of the Constitution. In the event the court determines that the election of the President-elect is invalid, it must make an order nullifying the election. Consequently, it has also to make an order directing IEBC to hold a fresh election within 60 days after the determination. Should the court determine that the election of the president-elect is valid, it shall issue a declaration to that effect. The court has then, as a matter of course, to make an order dismissing the petition with or without cost, as the case may be. In the strict sense, therefore, these are the only orders that the court may make under the Constitution. The court cannot assume jurisdiction that goes beyond the purview of Articles 163(3) and 140 of the Constitution. However, nothing stops the court from issuing orders or reliefs by way of recommendations. Indeed, since 2013, this court has issued many recommendations arising from the determination of 3 petitions challenging the election of the president-elect. The recommendations are meant to improve our electoral landscape and hence aid in the development of our democracy. In this regard, this court has been greatly aided by the contributions also of the amici curiae, and the court places a heavy premium on those briefs that were filed and those which were admitted. The final orders made by the courts. This is a unanimous decision of the court, and we make the following orders. 1, the presidential election petition number E005 of 2022 as consolidated with the presidential election petition numbers E001, 2, 3, 4, 7, and 8 of 2022 are hereby dismissed. As a consequence, we declare the election of the first respondent as president-elect to be valid under Article 143 of the Constitution. This being a matter cutting across the public interest, we order that each party do bear their own costs. It is so ordered. And finally, the court has asked me to also acknowledge, although we'll do it in the long draft, the enormous contribution made by counsel in these proceedings, and also the orderly way the counsel, all the advocates and parties conducted themselves. They remained seated throughout the proceedings. That is the judgment of the court, a unanimous one. We shall issue a media summary to help the media summarize the case. I think that is all. Thank you very much for coming.
My Lady, Madam Chief Justice, and the learned judges of this court, again, I am requested by my colleagues to thank you most profusely for your labors into delivering this judgment, listening to all of us, and giving our nation this judgment so that we may move forward. Thank you, and God bless you.
The Attorney General Emeritus to talk on our behalf. Next time you should talk to me. Let me similarly, on behalf of the lawyers for the counsel for the first and second petitioner, thank the court, and it has been a journey, worthwhile journey, sitting through these proceedings, and we thank the court for your patience and for the delivery of this judgment within the time stipulated. We thank you.
Madam President, members of the court, I wish to request just a couple of minutes for the chairperson of the Law Society of Kenya to make a few remarks in appreciation of the work that the court and Kenyans have done on this exercise, if you allow. Thank you. I call upon Mr. Eric Theuri to come and make his remarks. It is also his birthday. I would have sung happy birthday for him.
My Lord, the Chief Justice of the Republic of Kenya, the President of the Supreme Court, the Deputy Chief Justice and all the Justices of the Supreme Court, I think it would only be fair that I make my remarks after Counsel for the Respondents, Senior Fred Ngatia, makes his remarks to the Court.
Madam Chief Justice, thank you very much. It's so kind for the President to acknowledge that age goes before youth. Mine is to thank the court, to thank my learned friends for the effort we all expended. We thank this court for clarifying certain issues, and we look forward to a less corrosive 2027. Thank you very much.
Madam Chief Justice, Madam Deputy Chief Justice, it's so nice to have two madams at the same time, and members of the court. Since there are only men talking, I decided that I should become a woman and talk. It's become too much of a male affair in here. But on behalf of I think we were the third petitioner, I wish to thank you, and you've clarified the Regulation 87.4, which I was feeling very passionately about, that it was unconstitutional from what I've heard. But thank you very much for the time you spent, and we do apologize if at times we looked like hooligans. I mean, you have said we behaved well, but we didn't behave as well as we should have. But thank you very much for your time and for delivering this judgment.
Madam Chief Justice, Madam Deputy Chief Justice, members of the court, I, on behalf of Attorney General, take this opportunity to thank you most sincerely for a great job done and for the courage to clearly define the limits of the law, which will help us empower IBC on the way forward, and hope that this might be the last of the petitions after elections once we carry out a proper elections based on your guidelines. Thank you.
The Chief Justice and the Justices of the Supreme Court, on a light note, my members would be extremely worried if we take the submissions of Senior Counsel Orengo that this should be the end on account of fees. But my lady, the Chief Justice, on behalf of the Law Society and all the members of the society, we wish to, first of all, take this opportunity to thank the court in the manner in which it has conducted these proceedings, extremely efficient, especially in light of the really short and strict timelines that you've had. But the management of the proceedings, the manner in which the court adopted a somewhat inquisitorial nature to the conduct of these proceedings is something that as a society we have noted, and we wish to commend the court, and we do hope that the other courts, as they determine any petitions
election petitions that will go before them will similarly adopt such inquisitorial attitude, so that we try and really enrich the process that these proceedings intend to achieve. Secondly, I wish to also thank the Council, all the advocates who have appeared before you. They have demonstrated extremely high standards of decorum and courtesy, and have also demonstrated a flair for persuasion of the court, including the use of PowerPoint, and of course the now famous Pinky Pinky Ponky mimic. But all that really, I'm sure, has demonstrated, especially to the younger members of the society, how to conduct themselves before the court and how to really prepare a persuasive brief. And we thank all the advocates who appeared before this court for the good work that they have done. And of course, as a society, we feel extremely proud that they have been able to raise the profile of the advocates in this country a notch higher from their presentation. So, my lady and my lords, it's not lost to us that at the end of these proceedings, and once we are able to get your judgment after 21 days, that it is democracy and the Kenyan people who are the winners. The decision today, in a way, validates the choices that were made by the Kenyan people on the 8th of August, and they also help to build confidence in the institutions that manage the elections and the court. We recognize that no country is born as a democracy, and that it is a process, and the process of challenging an election, as has happened before this court, is part of the processes of building confidence within the electoral system. And we thank all the petitioners for choosing to challenge the results before this court. But at the end of the day, Kenya stands tall as a beacon of democracy, and we are very grateful that we've had this opportunity also as a law society to appear before the court and to give an amicus brief which the court has had time to consider. So we thank you and we wish you a good day. I know it has been a long 14 days, but you can rest, and we'll be looking forward to the decision that you deliver within 21 days. Thank you so much, my lady and justices of the Supreme Court.
Thank you, Mr. President. I have been asked by the President of our court to react to your submissions, and in so doing, I am obliged to say that we are truly humbled by the statements that you have just made. More humbled because those statements come from both sides of the divide. And thank you for appreciating what we have to do within a very short while. Thank you for appreciating that it wasn't our wish that we were doing what we were doing. We were doing the wish of the Constitution of Kenya 2010, the laws of the Republic, the facts of the cases that you placed before us, and the evidence in rebuttal. We know that as the President and I, whenever we have had time to talk to you in other fora, that we are incomplete without this side of the bar. We are incomplete without the advocates. We thank you. We will get opportunity to do that in the main judgment, in the reasoned judgment. But we really appreciate your industry. We were impressed by the submissions you took. And we were impressed, and we said this the last 3 days, I'll tell you something about that in a minute, by how deeply you believed in your clients' cases. That we think is a mark of an extremely grown legal profession, and we ask that you do not bring the bar down. You keep taking it up. In any contest of whatever nature, and even if we say there are no winners and losers, and even if we say that the winners are the Constitution and the people of Kenya, the truth is that some 6 million Kenyans will not be happy today. But that's the nature of the work we do. What we hope, and we hope you can advise your clients and our brothers and sisters that are the Kenyan people, that is what was expected. One side had to win. One side had to be in total or a great extent of compliance with the Constitution and electoral law than the other side. That's how we saw it. We thank you very much. We, the 7 of us, have not slept since we parted company on Friday. I think it is showing on our faces. And we thank you that you appreciate that we work under difficult circumstances, especially because of time. As ground rules, we agreed when we left you here on Friday that we would not pick any of your calls. A lot of you called us, but we just couldn't pick your calls. And I hope you understand that we couldn't. We saw that you were trying to call us, but we just could not pick the calls. I hope you understand. And now if you allow us, again, on behalf of these 7 men and women, thank you very much for appreciating what we have to do. Thank you for giving us the honor to serve this country in these capacities. And let's hope that we can continue to grow our democracy this way. And thank you very much for everything you also do for the country. And now you allow us to go home and sleep.
Thank you. The court is adjourned.
There you have it, the Republic of Kenya. The Supreme Court of the Republic of Kenya has ruled that William Samoei Ruto is the duly elected President of the Republic of Kenya and has upheld the election as announced and declared by the chairman of the IEBC, that is Wafula Chebukati.
Indeed, the 7-judge bench led by Chief Justice Martha Koome has made its determination on the petition based on 9 key issues raised in the 7 consolidated petitions that sought similar reliefs. And there you have it. It is a unanimous decision that has upheld the declaration of William Ruto as winner of the country's presidential election, rejecting claims by the Azimio One Kenya coalition candidate Raila Odinga that the electoral process was tainted by irregularities and illegalities. And we'll be looking much deeper into its determination and, of course, its ruling. And remember, Dan, those were 9 key issues that guided the Supreme Court in coming and delivering this particular judgment today.
Yes, and some of them were, all of them were heavy, but some had, keener interest on them, which include whether the declared president-elect attained 50% plus 1 vote of all the votes cast, in accordance with the Article 138 for the Constitution. And the Chief Justice says that there's a discussion about whether we are using, the votes which are rejected, the rejected ballots as well. Let's first listen in first to Wajakoya.
To be the official member of the opposition, we are going to put the government of Mheshimiwa Ruto accountable. And according to the way things go today, we know very well that the presidential candidates don't run through parliament. They run outside parliament. We have fought a war. We have fought a war the Supreme Court has decided. And what we would like to do is we should live in harmony. We should be patient. Kenya is not running away from us. You want to join me? Come here. Yeah, we have to live on. Life has to continue. We have had 6 million votes or voters that are currently crying, but let me tell them not to cry. We also have to thank Raila Odinga for having fought for democracy. The democracy we enjoy in this country is one of those that have contributed. We also have to thank Honorable Ruto for having fought a war that we have seen. We shall give him the courage we have to. But whenever he goes wrong, we shall tell him. And I've come out as a Kenyan to live in the opposition, if that's what people wanted. I'm not going to be running around waiting to be called on the table, just like what other people are doing. I am going...
Stand by this side, bro. Bro. Ameenda? Bro. Wewe ruka waya bwana. She's a client. The client is here. The client is here. Come on.
I think
the wheelings are ready. Carry on.
Okay, first is to
Hey, Mazen. Hey. Government.
First of all is to really thank God for the victory we have received today. We are grateful to God for this victory. As the president-elect said before, he has been prayed into victory. Kenya Kwanza has been prayed into victory. And we also truly want to congratulate the 5th President of the Republic of Kenya, His Excellency Dr. William Ruto. We thank God for you. We thank God that He has allowed you to reign over this nation for the next 5 years. And we want to thank God also for the Supreme Court Justice and the CJ for the unanimous decision. It makes it easier for the Kenyans to move on. And we want to say to all Kenyans that Kenya Kwanza government will not be just for the Kenya Kwanza supporters. It is a government for all the Kenyans. So do not feel left out as a Kenyan. Our doors are open. You belong here. We pray that there will be peace from now going forward. And don't feel as though you are not part of the incoming government. You are part of the Kenya Kwanza government. If you are Kenyan, we love you, we want you in, and we want to work together with everybody. We thank the judiciary, led by the CJ, for the great work they have done. They have done these proceedings in a very excellent, ethical and professional manner. The lawyers have conducted themselves very well, and we know that the democracy space in Kenya is growing, and together as a nation we can develop. Together as a nation we can concentrate on the issues that are affecting mwananchi. So it will be bottom-up economy for everybody. It will be a new season for everyone, and we believe we will grow together. Asanteni, God bless you. We will have our council say a word. Gatia, thank you.
What will do?
Gatia advocate, say something.
Yes, habari yenu. Yes, the client, the president-elect, will be making a statement later. Mine is just to say it's been a very, very engaging period, and we are thankful it has now ended. The time for court cases has ended. The time to assemble a new team has now started. We now move forward as one country and as one people. Asanteni sana.
So you will receive the statement from the President-elect, His Excellency Dr. William Samoei Ruto. Thank you.
Senator.
Maneno si rahisi.
Si rahisi. Hapo unaanza nyumba na kidogo.
Rengo ndio huyo. Pigeni magoti chini.
Teremsha mic kidogo. Usiongee.
Now substitute from
Well, are we all right?
Yes, yes.
First and foremost, I want to thank our team of lawyers. As we know, we are a team of nearly 50 lawyers, and we have been working very hard for the last 14 days, this being the final day. Secondly, we want to thank our clients, the petitioner number 1, Raila Odinga, petitioner number 2, Martha Karua, and other eminent persons in this team, including Senior Counsel Stephen Kalonzo Musyoka, for having their trust and confidence in this team of lawyers to prosecute their case in petition number 5, which has been consolidated with other petitions, and put their case before the Supreme Court. I want to say without a fear of contradiction that we do not agree with the decision of the Supreme Court. Like Al Gore, I will say we accept the decision, but we do not agree with it. And I am saying this as a seasoned practitioner that courts sometimes make mistakes which have to be corrected over time. Courts make political decisions. As you know, in the United States of America, there has been a long-standing case that has been held as universal truth of jurisprudence involving women's rights, Roe versus Wade. It took them 50 years to overturn that case because of a Republican Congress and a Republican president and a Supreme Court that was basically appointed by Republicans. And therefore, I want to say, yes, in accordance with the law, we got to accept this decision as the law of the land. But I think it is a very ideological decision. I think there are a lot of what was said in the judgment, and we'll have time when that judgment comes out to put out a critique. But all it means is that in our jurisprudence, the petitioners will always have a big burden to carry
when you have an electoral commission which is not open and transparent, the best way for this court to have made a decision was with the servers to be fully opened and all the election materials be placed before the court, as would happen in a case where justice has to be rendered. As you know, and I am saying this again without fear of contradiction, we wanted a comprehensive audit of not only the technology that was applied by the Electoral Commission, but we wanted a proper audit. Although time was of the essence, but I think we had sufficient time to carry out a proper audit, including looking at the issue of the foreign intruders, the Venezuelans, which you'd notice the court avoided in making any comment about those intrusions and invasions of the system, the technology, the IT structure. That again, the court did not refer to, but probably in the judgment, the recent judgment that is coming on the 21st, they will say something about it. And therefore, I want to end by saying the rule of law should prevail. The court normally has the last word in making a statement as to what is the law of the land. But as citizens who are sovereign, we're entitled to disagree, and disagree very vehemently. I think the court, in conducting the proceedings during the hearing, I think they were patient. They listened to us. It is only the outcome that we do not agree with. Finally, I think our clients, the two petitioners, Raila Odinga and Karua, may be addressing another press conference, but we are happy to talk to you on this issue. No, I mean forgeries. When the DCI, the Director of Criminal Investigations, what we put before the court, a lot of it was from an agency of government. I didn't see them talking about similar incidents in matters concerning the Independent Electoral and Boundaries Commission. That's why I was saying it was a little ideological. They were looking for things on which to destroy our case, but similarly not taking sufficient time to look at what happened on the other side. And that will be another story for another day.
So would you admit you might not have been well prepared for this case?
We were very well prepared. I think compared to 2017, we were a lot more well prepared.
What would be the 2 or 3 points of mistake that you say the court might have made a mistake on that?
In 50% plus 1, I think they were ideological. We are using the baseline of total registered voters in the land as against those who turned out to vote. If you read any legal material on what should be a turnout, including the Black's Law Dictionary, turnout is normally based on the registered members in a country as against those who turn out to vote. So there are so many other examples we can take up.
Given you lost on all grounds,
yeah?
On all the key 8 issues you lost.
The issues that the court formulated, but we're quite happy to live with it and talk about it another time. Philip, you would want to say something?
Just on the idea that we lost on all 8-9 points, we find it incredible that that could be the holding of the court. In more than several of those cases, we had overwhelming evidence. As my senior counsel, Mr. Orengo says, the servers were not opened. The involvement of the Venezuelans for a full month before, half a month before the elections and up to the 16th of August was not explained. No, it wasn't even offered. We perhaps a little distressed on the over-reliance of a registrar's report that has no input from us. That report was completely silent on the failure to open the servers. The servers, we repeat, the servers have all the answers. The exact role, we provided evidence that the Venezuelans were downloading documents, creating documents, and generating documents. None of that was touched. But as my colleague says, we hope they'll address all this in the final judgment. As somebody has said, it's incredible that we could lose on all points and they could win on all points. But as Senior has explained, it's probably the ideological aspect of this judgment.
Are you still confident on the 21st it will be a different ruling?
No. They have tied their hands. They can't get out of it. They have given their final decision. It's now a question of them finding the reasons for those findings and justifying them. It's not always easy, but I think they have some time to do it.
The other thing that I found a little bit disturbing is the presentation of the Form 34A by somebody I really respect as an advocate, Julie Soweto. It was described as hot hair, but you could see when that evidence was being adduced before the court, how engaged even the justices were. So I found it rather odd for them to describe it as hot air. I think that's why I'm saying this is ideological, because they would have said on the evidence presented, we find there was more weight as to the evidence which was adduced by the other side. But to say that it was hot air and it was a document coming from the Electoral Commission, I found it very, very disturbing.
If I may explain a little further on that point made by Julie Soweto in the petition, that gentleman, Camargo's name was not supposed to be on Form 34A. If at all he was involved in this election, he was involved on the technology side. So to find it anywhere near a Form 34A raised more questions than answers. There was silence. And of course, on the issue of the famous 34A that Julie was describing, it was found to have been signed by the agents of UDA and UDM on the 7th, which is before the elections. No mention was made of that. So many things, many questions, perhaps more questions than answers, but it is the decision of the court. They have to live with it just as we have. Is that all? Thank you.
Agenda, Professor Agenda may want to say something. Okay.
Sawa. Kuna mtu amemkanyaga yote hapa tu.
Well, those are live pictures from Sugoi and the supporters and residents of that area celebrating that ruling by the Supreme Court, where the Chief Justice Martha Koome-led bench has unanimously thrown out that petition by the Azimio la Umoja One Kenya coalition candidate Raila Odinga, arguing the declaration of William Ruto was null and void. Justice Koome says the court will issue a summary and then give the full judgment after 21 days. And we also did see some reactions from the legal representatives for the petitioners, that is Siaya Governor James Orengo as well as Philip Murgor. They're speaking about some of the issues, saying they do thank the petitioners for the time, they accept the decision of the court, but do not agree with it. They're saying the courts sometimes make mistakes, but of course they're looking forward to that full ruling scrolling to see their questions and arguments that are yet to be answered.
Yes, and we've also seen other reactions online by relevant persons, and one of them being Martha Karua, who's the presidential running mate for Azimio la Umoja One Kenya Coalition Party. And she has tweeted that the court has spoken. I respect but disagree with the findings. Same thing as what James Orengo and the rest of the Azimio team of lawyers has said. Aside from that, we've also seen a man who's been very vocal in regards to this, and that is Francis Atwoli, the Secretary General of KOTU. He has tweeted, during the KOTU Kenya Executive Board meeting on the 17th of August, we resolved that immediately after the Supreme Court judgment, we must thank and congratulate the victor. Consequently, we congratulate President William Ruto. We appeal to workers and Kenyans in general to remain peaceful. So that is KOTU Secretary General, that is Francis Atwoli. And right now we are expecting the president-elect to speak from his current residence, which he will soon be moving out of. And like Zainab had pointed out, the swearing-in is expected to happen next week on Tuesday. Indeed. That's the 13th of September 2022. Yes, next week Tuesday is when we expect the swearing-in. So in terms of just what is expected, we expect that the Interior CS is meant to gazette the day as a public holiday, so that we can make way for the swearing in.
And indeed, that is actually laid out in the Constitution, because you have the first Tuesday after 7 days of the pronouncement of the petition by the court. That's when that is set out, and in this case then it would end up settling on the 13th of September. That's on the first Tuesday after the 7 days, which is of course next week on Tuesday the 13th of September. Yeah. Let me just look a little bit deeper, Dana, into some of those issues as we continue to get those live pictures from the different parts of the country. That's with regard to this. Yeah, this is actually Karatina. You can see better on the screen. Well, the 7-judge bench today made its determination. Like I said earlier on, it was based on the 9 key issues that were within the consolidated petitions, which sought similar reliefs. So there was the first question, whether the technology deployed by IBC had actually met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Well, according to this ruling, upon considering all the pleadings, submissions, and the ICT scrutiny of the vote tallying and recounting report, which fully examined the IBC's election systems, they are saying they were not persuaded by the allegation that the technology deployed by IEBC had failed the standard of Article 86A of the Constitution on integrity, security, and transparency to guarantee accurate and verifiable results. They are saying, whereas the KIMS failed in 235 polling stations, more than 86,800 voters were granted right to vote manually, and forms 32A were duly filled, and that in their view, the petitioners failed to produce evidence to the contrary. Dan, I'll give you the opportunity to look at the second matter, which was whether there was interference with uploading and transmission of Form 34A from polling stations to the IBC public portal.
All right, thanks for that, Zainab. And before I even just chime in, I would just like to the DP, like I said, the president-elect, now we are used to calling him the DP, but the president-elect is going to be addressing the nation shortly. That's what you can see on your top left corner of the screen, as we see the different places in the country, parts of the country that are up in celebrations following the judgment delivered by the Supreme Court. And I just quickly want to get, as we just monitor the screens, quick comments from our guests in studio who are here from the previous session with Nur Abdulaziz and Nicholas Wambua. Wakili, what is your feeling about, what's your initial comment about this judgment?
Right. I think that this is great for the country. This is exemplary work done by the Supreme Court. As we said earlier, here is a dead-end road for at least those who were hoping to succeed and did not succeed. That's a turn of the road. I mean, they've got to immediately agree with the Supreme Court. We have seen comments from senior counsel, trying to say we don't agree with the judgment, but the judgment is there. That is neither here nor there. The truth is that the Supreme Court has made a finding that William Ruto is the duly president-elect of the Republic of Kenya. Every language and every tongue must change and accept and move with the Supreme Court and recognize William Ruto as the president of, because there is really nothing else you want to bring up. There is really no other alternative. The Supreme Court has spoken, the people of Kenya spoke, and it has now been concluded that William Ruto will be president of the Republic of Kenya. I think fortunes and dynamics now change. All the promises made by the president-elect, people will start counting going forward. Has he done this? Has he been democratic? Has he done ABC? I think the Supreme Court ruling has given him that leap, the chance to make things differently. Because there's too much, mud which has been thrown towards that direction. But the Supreme Court seems actually to have exonerated him to some extent when it says that the petitioners did not prove certain points. Even those points that they were saying probably he colluded with the IBC, all these things have been put to rest. So I think it's high time Kenyans realize that their president is William Ruto.
All right. Bwana Khalef, your also initial reaction to this ruling?
I think for me, what stands out is that this is a unanimous decision. They all sat down and they all agreed, that this will be a decision. So there is no dissenting voice, dissenting opinion, which means that, they've all seen the evidence from the same perspective, and they've agreed that this is something, as the Supreme Court, all 7 judges decided that, all the 9 points that were presented for, decision making, they've all agreed, that, as Orengo said it, all the points that were supposed to be argued were supposed to be, thought through. They've all decided collectively that this is the decision of the Supreme Court. And for me, because I know some of these judges, some of them, as I said earlier, I've interacted with them, I believe that, the evidence that was adduced in court spoke for itself. And for them to come up and unanimously say that, this is the way to move forward, I will urge Kenyans to accept that decision, to move forward. The president-elect and the president of Kenya is Dr. William Samoei Ruto. And now, as Kenyans, we need to come together. The challenge we have now is that we have a country that is somehow split in between. So the greatest challenge we have now is to bring everyone together, to maintain peace and to move forward as a country of around 50 million Kenyans working together to achieve the aspirations and the dreams that we have as a people.
All right.
Zainab, on behalf of the the losers, quote unquote, the Azimio fraternity, they must appreciate the fact that a president comes to lead the nation. A president does not come to lead a faction that has won. So the Constitution protects citizens from being probably discriminated or relegated. So all these social media hula balloons we are seeing all over, people being happy, fine. People must enjoy it today, tomorrow, but the truth of the matter is that a president, once elected, leads a nation.
All right. And I think we can still have those live pictures coming to us. Dan, you can see better. Maybe just give us an idea of where exactly we're coming to you live from.
So from your top left corner, we have Karen, which is the Deputy President's residence. And now we expect the President-elect to come and address the nation from there. Right next to it on the right is Karatina, which is in the county of Nyeri, which is where the Deputy President-elect, Rigathi Gachagua, hails from. He has been the MP for Mathira constituency, which sits in that county. To the bottom left, we have Sugoi, which is the hometown of William Ruto. So he's a son of the soil of Sugoi. Then we have Eldoret town on the far corner, next to our sign language interpreter, that's David Agondoa. We have Eldoret, which is the capital of Uasin Gishu County, which is where Sugoi is located. So this is where the president-elect comes from. So this is his home area, where we have the reactions that you're seeing on screen. We'll also be getting reactions from different various other parts of the country. And I don't know, can we listen into some of the celebrations, maybe from Sugoi?
Just before that, Dan,
Yes.
very quickly, we do know also the clerk of the Senate has called for a press briefing at around 3 p.m. And this is in light of the fact that President Uhuru Kenyatta has actually gazetted the first sitting of the newly elected members of parliament and the senators for Thursday, that's the 8th of September. That was a gazette notice that was released today indicating that MPs will be taking their oath of office during that first sitting. And of course, after that, the lawmakers will be expected to elect speakers of their respective houses. And that will be interesting to see how that pans out as well this week. So maybe we can get just a feel, some sights and sounds from those different parts.
sababu tuko live. Nataka tuambie hakuna nusu mkate, hakuna nusu mkate, hakuna nusu mkate. nyuma kabisa, nyuma kabisa.
Well, those are again celebrations from Sugoi in Eldoret in the county of Uasin Gishu, which is the home county of the president-elect William Samoei Ruto, which is one of the places that has burst into celebrations. And we are actually told that schools there have been closed today, just so that they can celebrate the son of their soil, having been confirmed, set for swearing in next week.
Indeed, and we can see, Bridget Singana is there, will be joining us shortly just to give us a sense of exactly the situation is there. But before that, let's head to Bondo in Kisumu County, Siaya County, I beg your pardon, where Zacchaeus Mwasame is on standby just to tell us exactly what is happening. Zacchaeus, a very good afternoon to you. How have the residents of that region received this ruling this afternoon?
Well, Zainab and Dan, we are still in Bondo. Kondele of Bondo. And these people are very exciting here. They welcomed us very well, and they have been following the announcement by the Supreme Court in regards to the announcement of that verdict. But where I am now, I realize that as many people were following that on TV and radios and whatever, this group of people where I'm seated, they looked not bothered so much. And I really wanted to find out why were they not even concerned that the elections or the Supreme Court was giving that very important announcement. And I want just to quickly talk to these gentlemen. Wewe unaitwa nani bwana? Alafu tutangalie ile kamera. Nimeona watu wanacheza tu draft hapa kama kama mahakama inasoma uamuzi. Angalia ile kamera. Tuelezee kwa ufupi kwanza majina yako alafu tueleze.
Naitwa Jaro.
Yes.
Naitwa Jaro.
Yes.
Kutoka Siaya. Nimeshukuru. Tuombe Maulana mwenye miujiza atutendee mema. Samoei William Ruto sasa ajipange tu vile atakuja huku Nyanza na apunguze mzigo ili tupate hata unga kwa bei rahisi, fuel kwa bei rahisi. Achana na mambo ya ufisadi, siasa sasa kando. Hiyo tu.
Asante sana. Songa kidogo niongee na huyu pia. Naomba usonge hivi niongee na huyu. Labda ulikuwa unasema you have something to tell us.
All right, you can see Zacchaeus Mwasame there has faced a bit of a signal hitch, but we will be joining him shortly just to give us a sense of exactly how the situation is there. But we can see that the residents quite laid back, accepting that result, Dan?
Yes, and you know it's significant because this is Bondo, which is where Raila Odinga hails from. Let's cross back to Bondo. I believe the signal is back on.
Maybe.
All right, we'll keep trying to get the sounds and the the views and the expressions of the people of Bondo, which is where Raila Odinga hails from. And it's like you can see, we're standing by with this, which is we're expecting an address by the President-elect William Ruto to the nation, having just coming hot on the heels of the Supreme Court's upholding of his election as the 5th president of the Republic of Kenya. It's a big day in Karen. There's already some videos we have seen where his wife was leading some prayers for him, as well as some of his members of his campaign team, and the leadership of Kenya Kwanza. They had some prayer session, and so we'll be monitoring to see when he gets to speak and what he has to say.
All right, and let's just cross over live down to Sugoi, where our very own Bridget Sangana is on standby. Bridget, a very good afternoon to you. We've seen elated residents and supporters there in light of this ruling. Just tell us exactly how the situation is on ground. Sangana, I think she's actually on our right here. So Bridget is on standby, just trying to get the proper, signal there from us, but we will be joining her in just a moment to get us and give us a clear sense, of the situation on ground in Sugoi. But of course, we will still keeping tabs on what exactly is happening at the Karen residence. That is the Deputy President's Karen residence is now the President-elect, expected to make a press briefing and of course a statement in a short while. We can see some of his staff members there just preparing that podium there for the President-elect to make his speech, and it will be interesting to hear exactly what he will be saying in light of this ruling. Let's head back to Sugoi, where Bridget Singana is on standby. Bridget, a very good afternoon to you. I'm glad you're back. Good to see you. Tell us what is happening.
All right, we'll be getting back to Bridget in not too long. We just seem to have a bit of a challenge getting through to her, but definitely a place we'd like to hear from, because that being the home area of the President-elect. We also have a lot of our reporters at different significant parts of the country. So we've seen Zacchaeus Masama is in Bondo, which is the hometown of Raila Odinga. We have Margaret Kimathi, who is in Nyeri, and Nyeri is the county where the Deputy President-elect, Rigathi Gachagua, comes from. We have people in different parts. We're going to be seeing how different parts of the country are responding. We have people in Nairobi. We have Ouko Kusa and team in Kisumu as well. So we'll be picking up the reactions from the different parts. Ruth Sarmoe is in Nakuru, which is also significant. And we are seeing a lot of celebrations in various parts of the country. And so